All right. Good morning, everybody. Thank you for joining me today. We are going to be going over the Tennessee exclusive right to sell listing agreement designated agency today. So we're going to go over every page of the contract individually, and then at the very end, I will stop recording and open it up for any questions or comments you may have. All right, let's get started. So, a few important reminders. The contract is the only thing that matters. If it's not in the contract, it doesn't matter. The contract may be accepted and still voidable. The offer is countered and a contract is amended. Special stipulations need the following: who, what, when, consequences if not done, and what may need to be contractually removed. You always want to be specific. So page 1, lines 1 to 2. Here you're going to put Dalton Wade Inc. and our address, which is our Atlanta address, and I have that listed here for you. Lines 3 and 4, you're going to place the legal name of the persons who are on title and the address that they currently live at, which might be different from this property. In a situation where an owner has given power of attorney to somebody, you're going to write John Smith, POA for Susan Smith, as an example. The property is owned by a trust. You'd put the name of the trustee. For example, John Smith, trustee for XYZ Trust. Lines 5 to 8, the seller is agreeing to give Dalton Wade the exclusive right to sell their property as long as the contract is adhered to. Number 1 is the property address, legal description. That's going to be lines 8 to 12. So here you're going to input the full property address, the deed book and page numbers, and you're going to need to run a search on realtracks.com for this property to find all of this information. Line 13. So here you could put the tax ID number or the legal description. And of course, these are going to be on realtracks.com as well. A covers included items. So this section lists all the items automatically included in the sale of the property. Make sure to go through this carefully, item by item with the seller so that they can make sure there isn't something that they specifically want to take with them. B, you're going to list here any items that the seller wants to leave with the property. And C, here the items are going to be listed that will not remain with the property. So whatever you fill in here is going to override whatever is written in line 16 to 26. So just a good note here, use this section for that purpose. Make sure all of the items are taken down before the property photos are taken, any of these items, very important. D is going to cover any leased items. So you always want to ask the seller if there's anything of importance leased that should stay with the property, like water softeners, and just list them here. Number 2, we have the listing price, and this is the price the seller sets. It's not your decision as a real estate agent, obviously, to choose the list price. All you can do is provide them with a CMA. You want to give them as much education on it and as much information as possible, and give them a good picture of the range in which their home could be worth. And then it's up for them to decide what they're comfortable with. Number 3 is the terms. So this describes the length of time the contract agreement will be in effect. This will be heavily determined by the state of the market. In a hot market in which homes in the area are selling for, say, 10 days, maybe you and the seller agree on a 60-day listing period. It's also common for the listing period to be 90 days or 6 months. All right, going on to page 2. So lines 42 to 46, here you're going to put the effective date. which is the date all the sellers have signed the document. So either you'll start marketing the property on the effective date, or if the sellers need a week to get ready, you're going to put that date on the last line. Line 47 is the carryover clause. Essentially, this contract protects you in any situation in which the seller might want to avoid paying your commission. So an example would be you get the listing agreement signed, you hold a successful open house, and then suddenly the seller wants to terminate this agreement. A few days later, one of the open house attendees decides they want to buy the house. So this clause ensures that so many days after the listing agreement ends, you'll still get a commission. Usually this section will state 30, 60, or 90 days. Number 4 is when possession of the property happens. So here, you're going to put either on the closing date or delivery of deed. Terms acceptable to seller. So here, you're going to put all the kinds of sale terms the seller is looking for. So cash, conventional, VHA, FHA, etc. Number 6 is compensation. So this is going to be the dollar amount or percentage that this will be the total commission amount agreed upon when with the seller that will be distributed to both the seller and the buyer's agent. So in Tennessee, there's no set rate or commission. Everything's negotiable. So you might put 6%, 5%, 5.5%. You could also agree on a flat fee regardless of the price point. In line 64, if this is applicable, you'll want to put the dollar amount or percentage for any lease agreements that might begin during the listing of the property in which compensation is due to the broker. Lines 80 to 90. This paragraph explains that in a situation in which an able buyer or tenant is brought to the seller, but the seller intentionally breaches the contract or, lease agreement, sale agreement, the seller still owes the brokerage the agreed upon commission and any incurred attorney's fees. It also states that if the seller wants to get out of the listing agreement, the broker can allow them to do so and may charge them for any marketing or other listing costs associated with this agreement. Number 7 is responsibilities and rights of the parties. So the broker is allowed to market this listing online, on MLS, or other listing services the broker is a member of. The seller acknowledges that the listing might be searchable on other websites affiliated with MLS, like through an IDX connection. So lines 100 to 102, this is where you will fill in what the brokerage will offer the buyer's agent in compensation. This is always negotiable and can be an area in which you could strengthen your contract by making it more enticing to other brokerages and their clients. The most common compensation offers seen here are 2%, 2.5, or 3%. Lines 103 to 104. In the event the buyer's broker is not a member of your area's MLS, you must state the compensation amount you'll be offering them here. Lines 111 to 120. This paragraph states the brokerage and subsequently you, as the real estate agent, are authorized to market the property as you deem fit, using physical, for sale, and open house signs, and that the seller will make the house available to you for showings during reasonable hours. If the seller provides you with photos or other marketing collateral, they are giving you the right to use them to market the house. Okay, lines 121 to 127. This section asks the seller to agree that the broker can receive all documentation relating to the sale of the property per this agreement, and that in some cases, the receipt of the broker counts as receipt of the seller. The broker agrees to follow the code of ethics in disclosing information relating to the offer, and the seller agrees to communicate effectively and often with the broker so they can respond promptly to any buyer's brokers who've submitted inquiries or offers. Number 8, we have Foreign Investment in Property Tax Act, so that's FIRPTA. If the seller is a non-US citizen, non-resident alien, or a foreign corporation, trust, or estate, they should consult an attorney or a tax professional to determine if special tax withholding should be collected at closing. This is the seller's responsibility. Number 9, hold harmless and limitations on broker's authority and responsibility. So in this clause, the seller agrees to review the MLS profile sheet and to complete the property condition disclosure, disclaimer, exemption, residential property disclosure form, and lead-based paint disclosure if applicable. The seller is not aware of any property defects other than those which have been disclosed on the forms listed above. The seller also agrees to indemnify the brokers and agents of any seller misrepresentations or omissions. Lines 155 to 157. The seller must follow laws regarding video and audio recording devices while marketing their home. Lines 156 to 165. The seller authorizes the broker and brokerage agents to hold open houses and conduct showings, which includes giving entry rights during these times. The seller also allows a lockbox to be placed on their property and authorizes cooperating brokers to gain entry into the house by using said lockbox. The seller must also keep insurance to protect them from property damage, loss, or claims, and the seller must also not hold the brokers liable for any loss, theft, or damage. Lines 166 to 181. A, the seller understands the broker may show other property to buyers who show interest in their home. B, the seller acknowledges that they are advised to seek legal advice on any concerns related to surveys, titles, title searches, property inspections, and any issues discovered. And the seller understands that the broker is not an expert in any of these specialties. C, the seller understands the broker has no authority to act on behalf of the seller unless specific in this contract and according to the rules governing real estate licensees. D, the seller acknowledges that the broker must make all disclosures required by law. And 10, expert assistance. The seller understands that the broker is not an expert in anything related to the law, square footage, acreage, home inspections, geological issues, wood destroying organisms, etc. The broker may offer a list of recommendations, but does not guarantee the services offered by these experts. Number 11, agency. Definitions. Number 1, broker. Any Tennessee licensed real estate broker, brokerage firm, and all of their licensees. So all of those people are going to be under the term broker. Number 2, designated agent for the seller. This is the real estate agent that has been assigned by the managing broker to work as an agent for the owner or seller. This excludes all other licensees in the company. The designated agent in the transaction has the sole interest of this seller and will work as an advocate for them, regardless of whether another agent within the same brokerage has a buyer. Number 3, facilitator or transaction broker. So a facilitator is not an agent for either the buyer or the seller in a transaction, but rather advises one or both sides and is not considered an advocate for either side. Until an agency agreement is in place, any licensee or brokerage is considered a transaction broker. Number 4, dual agency. Under this type of agency, a licensee can provide services to both the buyer and seller. Full disclosure and consent of both parties must be given if this agency relationship is to be used. Okay, we have adverse facts number 5. These are conditions that would be recognized as having a negative impact on the value of the property, reducing the structural integrity of the home, or that which possesses a health risk to the property's occupants. Number 6 is confidentiality. Under certain circumstances, a licensee must protect certain information. Any information revealed to the licensee by the consumer, which may be deemed helpful to the other party if it was revealed before the licensee disclosed an agency relationship, and information revealed to the licensee by the consumer after they disclose their agency relationship with the other party must be passed on to the other party by the licensee. B, duties owed to all parties to a transaction. By law, every real estate licensee owes these duties to every buyer, seller, tenant, and landlord. Number 1, to exercise reasonable care in providing services to everybody involved. Number 2, to disclose adverse facts they're aware of to both parties in the transaction. Number 3, to maintain confidentiality of information received prior to awareness of both sides that there was an established agency relationship. Number 4, to provide services with honesty and good faith. Number 5, to disclose up-to-date and accurate information about market conditions which could affect the transaction. Number 6, to keep track of earnest money deposits and all other property received from either side of the transaction. Number 7, to never act on behalf of the licensee's best interest or that of their immediate family or anyone else they have a personal interest in without prior written disclosure to both parties. And unless otherwise disclosed to both parties, with enough time for them to think about it and make a decision, the licensee will not recommend the services of a person or business in which the licensee has a personal interest or in which they might receive compensation. Duties owed to the client. Once the licensee has established a designated agency relationship with the client, they must also adhere to all instructions from the client, be loyal to their client's best interest, and place their client's best interest above everyone else's. Unless specifically waived by the client, the licensee must also schedule all showings, receive all offers, and send them to the client as soon as possible, answer all of the client's questions, and advise the client about what forms, procedures, and steps are needed after the contract is signed. Lines 257 to 259. If the duties in Section C are waived, the licensee must let the client know in writing that they cannot expect to ask for assistance of these duties. D, seller's authorizations. So appointment of designated agency. The seller authorizes the managing broker to appoint the listing licensee as the designated agent for the seller. This excludes other licensees within the brokerage, and the designated agent shall act in the seller's best interest and sole interest, even if the buyer is represented by another licensee in the brokerage. So you're going to put your name on line 265. Number 2, appointment of subsequent designated agency. Designated agent. So if necessary, the seller authorizes the managing broker to appoint a different agent from the brokerage, and this would be considered an amendment to the contract, and the appropriate documents would be needed. Default to facilitator in the event both parties are represented by the same designated agent. So in a situation where the designated agent represents both parties, they will default to a facilitator and must immediately notify the buyer and seller. As a facilitator, the licensee must act as a neutral third party within the transaction. Resumption of agency status. If the designated agent defaults to facilitator status, this will only last until the transaction is concluded. Number 12, earnest money or trust money. The broker is authorized to receive the seller's earnest money deposit for this property, and they are to hold it in escrow or trustee account. Title. The seller warrants that they are the vested owner of the property and that they have good marketable title with the authority to sign this contract and sell the property. The property will be conveyed with a general warranty deed. Number 14, home protection plan. So choose whether a home protection plan will be funded at closing or if this option will be waived. If provided, fill in the cost and provider on lines 290 and 291. Number 15 covers other provisions. A, binding effect, entire agreement, modification, and assignment. This agreement is binding for the parties involved, their heirs, successors, and legal representatives. This agreement can be assigned only with written consent from both parties. No modification to this agreement will be binding unless signed by all parties, and any assignees must adhere to all terms. Governing law and venue. This agreement is subject to the laws of the Tennessee state courts. Terminology. Context will be given to certain terms as they're used here, and days constitute calendar days ending at 11:59 p.m. local time. Severability. If any part of this agreement is deemed to be invalid or unenforceable, that portion will be separated from the remaining agreement, which will remain in full effect. Fair housing. The brokerage and licensees will not discriminate based on any of the statuses listed here and legal agreements. The seller acknowledges they have read and understand this agreement and that they should consult an attorney if they have questions. Confidentiality. Confidential information should be listed here. And 18, exhibits and addenda. So all addenda that's going to be attached to this agreement and deemed a part of the agreement. So you're going to want to list them there. And then special stipulations. So any special terms should be listed here and will supersede anything written above in the contract. Now we have the signing page. So lines 354 to 362, the broker or designated agent will sign. And then lines 363 to 373, the sellers and owners will sign. And that is all for today, guys. Here is your support team on this last slide. I'm going to stop sharing my screen, stop recording, and open it up for questions.